a reasonable public hearing. So many dramas that you don't want me to kind of like go into again, by the way. So, Kanu, how is this relevant to Kanu? It guarantees a fair trial, includes this section of the Constitution, guarantees a fair trial, including the right to know the exact charges and the legal basis. Kanu argues that the charges lack this, as they rely on a repealed act, making the trial unlawful. The court must exclude invalid proceedings to uphold independence and impartiality. There's another section of that law, 36, subsection 5 of that same law, your constitution rather, said every person who is charged with a criminal offense shall be presumed to be innocent until he is proved guilty. Why is this relevant to Mazi? Now, that also reinforces, by the way, that the prosecution must prove guilty. So must prove a guilt beyond reasonable doubt, as Section 135 of the Evidence Act 2011. Now, they are the ones to prove that Nnamdi Kanu committed an act of terrorism, not just this your social media copy and paste download videos that they think is actually relevant maybe to them, right? So they will need to prove more, which means Kanu's no case submission leverages this presumption, claiming no prima facie proof exists. So no defense is needed. That's his argument based on that your section of that your law. There's another one, which is 36 subsection 6A. Here it says, every person who is charged with a criminal offense shall be entitled to be informed in writing within a reasonable time of the nature of the offense. Now, how is this relevant? Mazi Nnamdi Kanu is demanding that the section of the law to fulfill this, without it, cannot prepare a defense, violating his right to adequate facilities. Section 36, 6D. Here is another part of your law. They say this one is, again, no, don't think, like I said, this is not a court, and we are not here to probably make any impression on you, especially those of you that feels like, oh, you should go and be setting. No, there's no point. That is what is happening in their court. Here you get. These are not something that anybody who understands what law means should hear and ignore if they are not really fulfilled. And then you expect a fair trial, fair judgments, and all of that stuff. So they have violated their own laws. You know, another thing that actually makes this particular trial illegal is that appeal court discharged and acquitted Nnamdi Kanu. Nigerian government disobeyed it, then approached the Supreme Court, right, to stay execution. And they want the Supreme Court to give them right to go and do a retrial, which means they want to go back to the same court and go and get their own prayers against Nnamdi Kanu granted. Meanwhile, the section of their law says, if anybody disobeys any court judgment, they have lost their right to approach court on any case at all for fair trial, for any fair hearing anymore. They've lost it. Because ordinarily it means that you do not respect the court, you do not obey the law. So if it doesn't favor you, you trash it. You pick the one that works for you. But law doesn't work like that. It is the same law that will release somebody who is a mass murderer and then jail someone who commit manslaughter. And you'll be wondering, how did that happen? Well, it is the law. But unfortunately, you have no choice. Once a court makes that pronouncement, you have to obey it. Yeah. And then you appeal it if you have the right to appeal in time. But these guys were like cherry picking, pick and choose. And they want to do the trial again in that same their court, asking for same prayer or something like a different prayer that they believe maybe the court will now grant that. So by that section of that law, they've lost that right. This whole thing is a sham. It's just a waste of time, right? Even if they come out tomorrow and make a pronouncement, Nnamdi Kanu guilty, let the media run with it. Because that is a pre-concluded sort of like end anyway. Now let me read more, right? It says here, it said, section 36, subsection 8 of your law says, no person shall be held to be guilty of a criminal offense on account of any act or omission that did not, at the time it took place, constitute such an offense, and no penalty shall be imposed by any criminal offense heavier than the one that would have been applicable at the time the offense was committed. Now, of course, I'll tell you how this is relevant, and I'll explain it. So, what that section simply said is that it nullifies the charges under repealed laws, like the 2013 Act, as the 2022 Act changed the framework. Kanu cites this to argue the charges are retroactively invalid. So they arrested me. They said, anybody who incites public to so and so, right? This person will be charged for incitement. Okay? And then, and if that incitement leads to any form of destruction of, or maybe loss of lives, it could be tried under Terrorism Act. I'm just making that up now, like an example. And then they were trying Nnamdi Kanu on that. Based on this, their current charges. So they are charging him on a 2013 Act that has been repealed. It's no longer valid. So there is another one with a different framework that says, those who carried AK-47, those who did this, those who did that. Here you get. So that simply means you can't try somebody that you've held in detention and been tried under a different law. You can't keep him and try him under that same old law. You would have to probably, like, technically, right, they've got no case. Technically. But we all know they never had one. So there's another section of your law, section 36, subsection 12. Listen to this part. It said, subject as otherwise provided by this constitution, a person shall not be convicted of a criminal offense unless that offense is defined and the penalty therefore is prescribed in a written law. Ask them now that what is, like we're asking about the law that they are using to try Nnamdi Kanu. So under this their law, what will be the punishment? Because Nnamdi Kanu needs to know. Do you get me now? Like, they are accusing him of something, right? And he needs to defend himself. How is he going to do that? You have to tell him, outline every section of your law that says, this thing he did is committed a crime here. This one is committed a crime here. Then when you pull everything together, you realize that this is not even a terrorism charges. Here you get. Like, by the time you start reading all those things, you are writing that this is not terrorism. This is not terrorism. We say it's terrorism. This is not terrorism. But we need to say it's terrorism. So, because you put it out and say, well, let's just say it's terrorism, then we know it's not really terrorism. So here, they said directly how this is going to affect Nnamdi Kanu's stand. Directly supports Nnamdi Kanu's core demand. Offenses must be defined in extant current law. He claims the charges fail this, rendering them nullity. Those of you who were reading that Nnamdi Kanu, why would they just say he's not putting up a defense? You heard this whole thing now, right? Did any of this sounded like somebody who didn't know what he's talking about? Are the media and even their judicial correspondents, are this kind of like relaying this to the public and tell them that, listen, look at what your government is doing. This is what your law says, right? And this, so far, is how they have been treating this person. Somebody they have kept under solitary confinement for so long. I'm talking about for years. He's been limited access. They've limited his access to have, sunlight, fresh air. They limited that. They limited his access to medical care. They limited his access to worship or, practice his own religion in their detention. They have physically assaulted him. They have psychologically tortured him. And they do that to him every day. That is the person Nigerian court is expecting to go and put up a defense. They didn't give him any access to have, his own case file where he could study it, discuss it with his own lawyers. And his own lawyers, right, will take note from him in order to build his defense. All of these have been denied. Then they gave him 5 days to defend himself. Out of that 5 days, 2 days gone, because out of that 5 days, 1 day out of that was used in reviewing his own case, and he discovered that, look at these guys, this is a pure waste of time. They've got no case against Nnamdi Kanu. So the judge now said that, okay, if that's going to be your stand, you have to put it into like writing, your address. So, and that is expected, right, from the 4th to the 5th and the 6th of November. So Nnamdi Kanu, they would have the time, because they said his address, this is how they are doing it, to say his address, which will be on the 4th. They will put all of this in a proper address to the court. Say, based on this, based on this, based on this, based on that, I do not have any defense to put up until they can prove that what they are doing now is covered under a certain law. And if then I can put up my defense and call it the witnesses. So the court now says, okay, put that in writing and send it to the prosecution team, the people who are persecuting him, to have this copy. So that when they meet in court on the 4th of November, right, they would expect the opposition, the persecutors, they will be expected to probably present their own address too. And their own address is going to clear the position of Nnamdi Kanu or even validate it. So if they decide to say, no, we are trying you under a right law, the correct law, okay, let your judge, let him decide then, because I've got nothing to say then. So you, Mr. Judge, go back into that constitution then and read all these parts and tell me if I am wrong. Okay, you, Nnamdi Kanu, you are wrong. Okay, fine. So then they go to appeal again. That is what some of these guys are saying, is intentionally delaying them. Delaying who? Delaying criminals that are that don't have any intention of giving him any justice. Are you so kind of like, like so unbothered with truth, right, that you still feel like it should give them what they want? No. They would have to actually use their own hand or their own rope to hang themselves. What is your fear? Oh, they will just send them to jail. Somebody who has been in their detention for more than 10 years, in and out of it. It's not had a normal, proper, a family man, kind of like a relationship with his family because of this. He's not been able to actually witness the burial of his own parents because of this. So do you know how much he's actually lost, that you suddenly on social media, you are feeling concerned for him? No, we know it is not about your concern, because majority of you don't really care what happened to him, what has been happening to him. It's only once in a while when their media brings all this sensationalized news, which most of the time it is to divert your attention away from the real thing. Imagine if a lot of you actually understands this judicial manipulation, this corruption, and its impact on their entire judiciary image in that contraption. Do you think it won't be a different story? So again, it's got nothing to prove to them. Now, in that same Abuja, right? Omoyele Sowore, Aloy Ejimako, Emmanuel Kanu, which is Mazi, Nnamdi Kanu's brother, and 11 others were released finally from Kuje prison after fulfilling their bail conditions. And they reminded everybody that the gate of their prisons can't really hold their people when the time comes. Omoyele Sowore and others, right, living in Kuje. But before we even get to that, I should add that a politician who once vowed to be ready and willing to stand surety for Mazi Nnamdi Kanu who is now the promoter of the creation of annual states as part of the new 50 states they are planning to create in Nigeria. 50 states and then 276 local government extra. So it was with Sheung last night, and as somebody, right, who I believe is in the know, he had this to say: the detention of Nnamdi Kanu, the whole thing, is a pure disaster. It is like Nigeria got stuck in a place and they have no idea of how to get out of it. To save face, they continue the sham trial. And it's not saving their faces.
On the floor of the Senate, and you have argued with your colleagues the need for an annual state, and don't even begin the conversation around marginalization, because that's the first thing, because people will say we have Southwest 6 states, South 6 states, Northeast 6 states, North Central 6 states, Northwest 7 states, but Southeast 5 states. Is that part of the agenda to fix the Southeast that seems to be smaller in terms of the number of states, or what?
Well, almost just over a year ago, I had a meeting with the President Bola Ahmed Tinubu, where I discussed about the problems of Southeast, the insecurity in Southeast. What do we do to address it? And he knows the problems, and he also has an idea. The whole idea is that there should be some level of equity extended to the Igbos of Southeast by having an additional state. It wasn't going to be an easy task, to create one, but it is doable. And I'm happy that we have come this far. The point is this: even at that time, it was understood that the problems of Southeast, the agitations of the youths of Southeast, the killings there, the referring to the ESN groups and ESN and IPOB and the rest of them. These are young people who have come up to say that they are fighting for freedom because they are marginalized. And one of the areas that they've all spoken about and against is the fact that they are the only zone. Southeast is the only zone in Nigeria that has 5 states. Why is that? Why was it done intentionally to undermine them? Of course, yes. And from engaging those youths, it became so obvious that if a step is taken in creating one state, just one state, to bring it apart with 5 other zones, let's leave Northwest out of this now, at least bring it apart to the 4 other zones, then something would have been done for them. Yes, they are clamoring for different things, but I mean, not least, of course, the release of Nnamdi Kanu. They're asking for it. We know that is something that has to be done. You will just say
Nnamdi Kanu to be
released. Yes, yeah, of course.
Why do you think so?
Nnamdi Kanu has been in custody for some time now. I believe that he has been held unjustly. Many people feel that way.
As a lawyer, do you think so?
Oh yes.
That the judicial process is unjust?
Yes. Yeah. No. It has been. There's a lot of delays in prosecuting him and all that. If you want to get him tried and convicted, get on with it. But this is a guy who has been held unjustly aside, for so many months.
And the Buhari government started it.
I'm not talking about this government.
Trial. No, so the point I'm making now.
I'm talking about the previous government under Buhari when
it's facing a judicial process right now.
Yes.
Saying it's just because the argument is that there should be a political solution, maybe a null prosecution. Prosecution should be established on that for the case to be withdrawn. But there are those who say, well, there are allegations and it's left for the law for him to have his day in court, which is in process.
But as you know, there have been some pronouncements by the Federal High Court, which has not been respected. you know. So his incarceration is the main reason for the crisis in Southeast.
But the crisis started before he was even arrested.
No.